entitled Leaving Homosexuality, which includes papers entitled The Right to Counseling for Same-Sex Attractions. What do we mean when we talk about change from homosexuality? And homosexuality, real hope and real change. In conclusion, this rule is necessary to protect the mental health of children in our state and reduce suicides among young people. Please vote no on the motion to suspend the rule.
Okay, questions or comments? Senator Knauss.
Yeah, I just wanted to get us back to where we are regarding the difference between, and we had legislation previously that the legislature did not take up regarding this issue and policy. The legislature has its legislative duties, the board has its duties on ethics. And what's being inserted here at this point, as I look at the unprofessional conduct in 2002, everything in here, reporting, dating a patient, keeping records and so forth, it all, anyone looking at it casually would think this deals with their authority to regulate ethics. It doesn't get into what you can do as far as therapy at all. Now it does, which jumps the fence. That's a legislative duty. And that's where it belongs. And I'm sure we're gonna disagree on that, but that's where it belongs. The legislature, if we were to accept this in any other department, and we have stopped rules before. I remember one actually went to court. It was on fire code and fire detection where it went too far, and that was repealed. So what it is, the legislature has, as I said, their legislative duties, and the board regulates ethics. And everything I look in here, in as far as ethics, with that one exception of what you're debating today, which belongs in the legislative arena and in a legislative committee, everything here seems common sense as far as records and charging, failing to comply, knowingly aiding, assisting, and so forth, all is ethics. Makes sense. This gets into a policy decision, and that's where we have a disagreement. If we allow that to happen, this can go in, and other policies in the future, it will set a precedent, and I don't know where it'll stop.
Thank you, Senator. Senator Royce?
Thank you. You've been around this building a long time, Mark. Are you a social worker?
Yes.
And I'm not. I'm an attorney and a small business owner. Of the 132 legislators and the governor, roughly how many of them currently would you say are either marriage and family therapists, professional counselors, or social workers?
There aren't any in this legislature that are social workers, marriage and family therapists, or professional counselors.
Weird.
So, if there are none, doesn't that lend credence to the idea that it is really, the legislature is not competent to decide what is professional conduct in a particular regulated industry?
Yeah, I mean, we accept the fact that doctors regulate what's professional conduct, and nurses do, and chiropractors do. You know, none of us can tell doctors what's professional conduct and unprofessional conduct, chiropractors, because we know it's the professional's role to do that, and that's exactly what's happening here. And, you know, that's, the professions are there to provide this incredibly important service, and we're the ones that make the decisions on what's professional conduct, and that happens in all the professions.
So like barber cosmetology, real estate brokers, insulation installers, they know what the standards are for their profession.
Right.
And so they're the ones that are making those rules.
Yeah, and this has been, the condemnation of this has been there for decades. I mean, it is, all the mental health professions have said that this is unprofessional conduct for decades and decades. We know it is, and that's why we're putting this into the conduct code, because it is unprofessional conduct.
And to your knowledge, is there any mainstream healthcare provider organization that supports conversion therapy and says that it it can be professional
No,
conduct?
none.
Not. Well, thank you.
Senator Larson?
Thank you. I appreciate you coming, Mark, and giving testimony on this again. We were doing this, again 2 years ago, and kind of doing the same kind of dance routine, unfortunately. But I'm drawn because I think we may have jumped over it, and I appreciate Senator Nass pointing out that this is just one thing and trying to get back to the core of this. So we didn't have a chance to be able to actually read the what is actually included in the marriage and family therapy, professional counseling, social work examining board code of conduct, and this is something that came out in November of 2022. So just to be clear, this is in effect right now.
Correct. Yeah, it's been in effect since December 1st.
Okay. So this is already in effect that conversion therapy is banned, as well as all of the other,
Right.
just count them real quick, 31 different codes that were in here.
Yes.
And this is just one specific that's getting pulled out.
That's
Do you
correct.
have with you number 25?
Right, that's correct.
Do we have, would you be willing to read, do you have it in front of you? Just so everyone's aware of exactly what's changing here, what's being pulled out. We haven't had a chance, this committee and the public may not have seen it. I would just make sure we're to the heart of it, of what the code number 25 is.
Yeah, I have it here. Do you want me to read it?
Yeah, you have a better voice than I do.
Okay. So, employing or promoting any intervention or method that has the purpose of attempting to change a person's sexual orientation or gender identity, including attempting to change behaviors or expressions of self or reduce sexual or romantic attraction or feelings towards individuals of the same gender. This does not include counseling that assists a client who is seeking to undergo a gender transition or is in the process of undergoing a gender transition, or counseling that provides a client with acceptance, support, understanding, or that facilitates a client's coping, social support, identity, exploration, or development. Nor does it include counseling in the form of sexual orientation, neutral or gender identity, neutral intervention provided for the purpose of preventing or addressing unlawful conduct or unsafe practices, as long as the counseling is not provided for the purpose of attempting to change the client's sexual orientation or gender identity.
And so that, just to be clear, just to be clear, thank you, Mark. Just to be clear, that is the only issue that is, of all the 31 that's come up today. The question I have is, you brought up the Ledge Council memo, and my question is actually for Ledge Council, if there had been any changes to this, and I believe I believe Ledge Council who's here is actually the author of this, so you might be aware if there's any changes to the Ledge Council memo that was cited in his testimony, and if you could let us know if that has changed, or if this is still the guiding statutory authority for these boards to promulgate rules regarding unprofessional conduct.
Senator, you asked a couple questions. I'll try to answer them in sequence. The statutes cited in terms of the board's authority, 15.08 sub 5 and 457.03 sub 2 have not changed, and as discussed so far, including by Senator Nass, they speak to defining and enforcing professional conduct and unethical practices not inconsistent with the law relating to a particular trade of the agency. The memo also, the conclusions reached were in the context of what it was at the time, the recent Supreme Court decision, Legislature v. Palm, which made some added discussion and opinion and direction to the state of administrative rulemaking in Wisconsin, and spoke specifically to the questions of whether authority is explicit or specific enough to justify an agency's rulemaking. In looking at the MPSW rules on unprofessional conduct, we had reached the conclusion that on the statutory authority question, these grants of statutory authority were likely to be unchanged by the Palm decision. I think it's important to point out, though, that the committee's authority extends beyond suspending rules simply because they lack statutory authority. That is one of the stated grounds on which the committee can take action. The others include emergencies related to public health, failure to comply with legislative intent, conflict with state law, changing circumstances, and arbitrariness and capriciousness or imposition of undue hardship. So that memo also points out that it's not a statement about the committee's inability to act under other grounds for suspension.
Thank you, Ledge Council, I appreciate that. And I think it's helpful to be able to say that very, very clearly that there is the statutory authority for these boards to be able to promulgate these rules. And just to go back to our to Mark who's testifying here, if these codes were come up with, the code of conduct was come up with within the scope of their own statutory authority to be able to put these forward, or if it was done under duress, or if somebody else was pushing for these things, or if this is something that is an internal governing authority to be able to say, if you're going to practice marriage and family therapy, professional counseling, and social work examining, or social work on this examining board, that this is the scope of what is acceptable. So just making sure that when this was put forward, that fell within under the statutory authority granted to it.
Thank you. We have a few more.
Sorry, I just wanted to.
Sure.
He's nodding for those who are listening.
I don't know if we have any role here. I just want to, we have a few more on the list, but as long as we're on 25, we're going over that. I just want to point out again that, in all of that, there's nothing in there that says anything specific to minors, right? I mean, in other states, there, has been a push specific to minors. In this, there's not. Your own numbers, it sounds like you cited over 60% of the people in doing conversion therapy are adults that would be, willingly enlisting this therapy. And I'm just curious, without making any moral judgments or preconceived ideas about who that person is, I mean, that person that is seeking that therapy that can no longer get it, does that not feel like a policy change in the state of Wisconsin?
No, it's basically expression of unprofessional conduct. This is harmful. Mm-hmm. And a therapist, like a doctor, there's a power imbalance there, and they can influence people. And this is just plain unprofessional. It's dangerous, harmful conduct. And you could look at other professions. It's not a policy. It's unprofessional. It's unethical. It's harmful. The expression "do no harm" for doctors, that applies here directly. This is extreme harm. It's unprofessional for any social worker, marriage and family therapist, special counselor to engage in this with anybody. It's particularly harmful for children, but it's also harmful for adults.
With that 60% plus, and I'll move on to the other question, but with that 60% plus that you've cited, I mean, would you be willing to say that they voluntarily have sought this therapy?
I don't know the individual circumstances. In many cases, you have 18 and 19-year-olds who go for therapy, and maybe, their families and parents and family members say, pressure them to do so. And I mean, there's such homophobia in this country that, people have struggle with being able to accept who they are, and there's a lot of prejudice and discrimination and such stigma towards that people